Welcome to IP Ethics and Insight. I'm Emil Ali, and this is Mike McCabe. And today we're going to talk to you about 5 things you should consider if you've received a request for information and evidence from the USPTO's Office of Enrollment and Discipline. So Mike, why don't you take it away and tell us what's your top couple things to think of when you've gotten an RFI from OED?
Sure. Number one, you have to take the matter seriously. OED investigations are very important events in a practitioner's life. And more importantly, every practitioner has an affirmative duty to cooperate with an OED investigation, which means that OED respects timely, fulsome, complete responses to their questions. The second thing that one must think about when they receive a request for information from OED is resources. Do I have the resources to respond to this inquiry? And there's really 3 types of resources that I'm thinking about. Number one, factual resources. Do I have access to the evidence and information required to fully respond to the questions? 2, legal resources. Do I understand the rules of ethics and how they are being interpreted and applied to the facts that are implicated in the request for information? And 3, do I have the time to commit to the project of preparing and collecting the facts, identifying and analyzing the law, and putting together a comprehensive response to the request for information? And that takes it can take quite a bit of time to prepare the type of response that the OED expects is required.
Those are really, really good points. And I'll just add maybe a few others. Reporting is a really big thing, right? Whether you work in a law firm, in a nonprofit setting, in-house, you're generally going to be a fiduciary, whether to your employer or if you're a partner, to your other partners. So notification to your employer or partners might be required, right? It's may not be specifically written into your agreement or your contract, but it's implied that you're a fiduciary. So first thing is probably let them know, let the higher ups know that there's a problem, whether it's from this firm or a prior firm. Also insurance, right? One of the things that we deal with a lot is, well, a client says, I don't want to report this to an insurance carrier because my premiums will go up. And that very well may be true. But generally speaking, most policies require you to notify them of a disciplinary complaint or investigation within 30 days of the date. And if you don't, you still have another duty to do so at the end of the year when you're applying, reaffirming or re-signing that declaration where you're requesting insurance. So those are really important things, but also reporting to the client, right? Whether it was the client that filed the grievance against you, or if it was just something that involved the client, maybe it was a competitor, it may be time to report it to the client and potentially seek a waiver. Another really important topic is privilege and confidentiality, right? That's something that we deal with on a regular basis. Has privilege been waived, or do you want to waive it? Mike, what are your thoughts about privilege?
Right. Privilege is a very important issue, and it comes up in all of these investigations. And there's sometimes where you have the right to waive the attorney-client privilege and use what would otherwise be confidential and privileged communications to respond to the OED. There are other times, however, where you have an affirmative duty to not reveal that privileged and relevant communication and respond, and to maintain and protect the client's rights of confidentiality. And it's different in every investigation. One has to consider, how do the rights of the client with respect to confidentiality and privilege apply, and what happens if you produce and provide confidential and privileged information to the regulator? Does it constitute a waiver of the attorney-client privilege? Is it going to create ancillary liability or issues for your client? And is it appropriate in your case to rely on privileged or confidential information, or is it appropriate to withhold that information just as you would in a typical litigation?
And I'll add one point. There could be intervening state law issues or state conduct issues. If you're an attorney in California, you may have a statutory obligation to uphold that privilege or confidentiality. But I think to round it out on the top 5, I would say remaining calm and objective, right? That is going to be really important. You want to be able to understand what the issues are. What are these rules of professional conduct, right? Any other thoughts?
The really hard part is, how do you objectively answer consequences that go to your own conduct. Because when you receive a request for information, it is an anxiety-provoking event in a lawyer's life. Often they've never received anything like this before. And so one's initial reaction is to defend themselves, to get defensive, to be upset, to be anxious. There may be a feeling of wanting to lash out at whoever filed the grievance and to blame the blamer. And that could be a problem when you're going and trying to objectively represent yourself before the regulator. The regulator is going to want to look at things much differently than you might want to think that they would look at. So if you were to, it may very well be that your ethical obligations require you to concede or admit that you engaged in wrongful conduct, or to admit certain things that you wouldn't necessarily ever want to concede or admit to in a general civil litigation. But ethics investigations and disciplinary actions are not your typical civil litigation. And so what flies or what types of practices would work from a malpractice standpoint often don't really work in a disciplinary function, where bar counsel is going to want to see whether, if you've made a mistake, have you learned from that mistake? Have you taken corrective measures to avoid the mistake occurring again? Are you admitting your wrongdoing and figuring out what are the root causes of that wrongdoing? And so these are the types of things that a level of objectivity is going to be required so that you could help you self-reflect on the events and circumstances that caused the request for information to be instituted in the first place, so that you can present yourself in the best way to the bar.
That's a really good point. But piggybacking off of that is candor, right? And when you're trying to be candid, or when you're emotional, one of the first things you think about is, I should just say this, or I should just say that. And responding to OED definitely involves being candid, being truthful. But sometimes you have to balance being candid and making admissions. And a lot of people will say, well, I don't want to admit to anything. Well, I think one of the things with OED is taking one and saying, you know what, I acknowledge that this was a mistake. Sometimes that's all they need to hear. They need to hear, I made a mistake, and this is how I resolved the mistake, and this is how it will make sure it never happens again. Sometimes that's all you need. And to get to that point, you need to cut out the emotions, right? Talk about the corrective action. And I think a lot of that comes with understanding the best practices of working with OED, because they are just like us. They are great attorneys that are there to do a specific job. And I think if I could say one of the worst things that you could do is get argumentative and disrespectful with the OED staff attorneys that are just doing their job.
That's absolutely right. You want to treat the OED just like you would be treating a federal or state court judge. You want to treat the OED staff just like you would a federal or state court judge and their staff. You want to be polite, kind, responsive, and dealing with yourself professionally, because this is a professional conduct review. And we as professionals are always subject to oversight by the bar. And what the bar is really looking for is, number one, does this person get it? Do they understand that they made a mistake? Are they candid about the mistake? And are they willing to make amends and to make things right? Have they learned from this mistake, and has the public protected by our job here? And if we can do all of that, we can certainly help mitigate and minimize the potential adverse consequences that could arise from a USPTO investigation.
Well, thanks so much for joining us for IP Ethics and Insight.